So this has apparently been like the week of modifications. I have been nonstop on the phone with people all week long about modifying their parenting plans, modifying time sharing, modifying school locations, modifications. So I thought, you know what, I've said this at least 100 times this week. Let me just do a video blog on it, and I can refer people over to it and hopefully educate people a little bit about how the law works in Florida as it pertains to modifications and parenting plans, which includes time sharing as well as decision making, which we call parental responsibility. So once you have an order on time sharing or parental responsibility, once a parenting plan is in place, it's signed by the parties, ratified by a judge, in order for you to modify that parenting plan, either as it relates to decision making or as it relates to time sharing, you have to first kind of jump over a hurdle. And that first hurdle is that you have to prove that there's been a material, substantial, unanticipated, permanent change in circumstances, which is a lot of words. But basically, something really big has to have happened that makes things different today than they were at the time that the order was entered into, or the agreement was entered into, or the order was entered. So something has to have really changed, and before you can just modify a parenting plan, the court needs to see that something has really changed, that something is much different today than it was then. So I can't tell you exactly what is or what isn't a substantial change in circumstance, although I could give you some examples. For example, if somebody has married someone who has a criminal record and they're now living with that person, that certainly is. If someone's developed a drug or alcohol problem, obviously that's a substantial change in circumstance. Potentially, if you're living in different areas, work schedules maybe have changed drastically. There are a lot of different examples of things that might constitute a substantial change in circumstance. And then there's a lot of things that don't really. Like, for example, that the child has just gotten older, and that someone or that the child has expressed that they just would rather live with one parent than another. Those kinds of things may or may not qualify, very likely do not qualify. The other thing that comes into play is your judge. Judges can see these things differently, and what one judge may think qualifies, another judge doesn't. Now, we do have some guidelines and some case law that we can look to get guidance about what may or may not qualify as a substantial change of circumstance, but the important piece of this is that it's very subjective, it's super individual from case to case, and it's definitely a legal question that you need to talk to an attorney about before you jump into a modification. So once you've proved that there has in fact been a substantial change in circumstance, then the next layer of the analysis about modifications is what's going to be in the best interest of the child. Now, most clients want to jump straight to what they believe is in the best interest of the child, but you can't get there unless you get over the substantial change in circumstance hurdle first. Once we get to the place of what's in the best interest of the child, we have a lot of guiding factors to look at. And we also have a lot of different tools that we can use to try to convince a court of what we believe is going to be in the best interest of a child. So the modification process from beginning to end can be almost as long as the initial process sometimes. And depending on exactly what you're trying to accomplish, in some instances, it can be even more complicated. Other times, it doesn't have to be that complicated, and we can get it done fairly frequently. And like always at my law firm, if it's ever possible, we try to reach agreements and keep people out of court because it's better for kids, it's better for your pocketbook, and it's better for relationships. Occasionally that can't happen, and we end up having to have judges make decisions, and then it's our job to do the best that we can to convince judges of what we believe is going to be in the best interest of a child. So happy Friday. If you have questions about your modification, let us know. We're happy to help.